Thank you so much for being here. My name is Sue Murphy, and I proudly serve as the president of the Robert H. Jackson Center. It's my pleasure to welcome you all here today this morning. 2017 is the Jackson Center's 16th year of promoting liberty under law through the examination of the life and work of U.S. Supreme Court Justice Robert H. Jackson and its relevance to current events and issues. Our work is quite varied. We develop and present educational programs and exhibits for the entire spectrum of ages. We facilitate research, we provide college internship experiences, and much, much more. Through our initiatives, collaborations, and strategic alliances, we touch literally tens of thousands of lives each year, locally, regionally, nationally, and internationally. Overall, we are educators, expanding awareness and informing the dialogues taking place in classrooms, at community and corporate leadership tables, and within institutions of higher learning and public policy in our region, across the nation, and around the world. Much of our programming develops quickly as current events occur and opportunities arise, such as this one today. So I encourage and invite you to join our mailing list and visit our website and Facebook pages regularly to learn about additional programs, news, and information that you will want to know about, participate in, and support. Today's program fits squarely within our mission to engage, educate, and inspire the largest possible audience on issues and challenges facing us all. We are delighted to convene such a dynamic group of experts, practitioners, and educators in this symposium and dialogue on the complexities of immigration, security, and law. This program is made possible through the generosity of our donors and the following funds established at the Chautauqua Region Community Foundation: the Alan Y. Cole Lectureship Endowment Fund, and I'd like to recognize Chuck Cole, representing the family of Alan Cole here today. Thank you very much, Chuck, there he is, for your support. And thank you for being here with us today. Also, another fund at the Chautauqua Region Community Foundation, the Stanley A. Weeks Charitable Legacy Fund, and Libra, and we have a representative here from Libra today as well. There you are. Thank you. And now I'm very pleased to introduce the mastermind behind today's program, John Q. Barrett. He really needs no introduction. John is professor of law at St. John's University and the Jackson Center's Elizabeth S. Lene Fellow, that's a tongue twister, and a member of our board of directors. He's a graduate of Georgetown University and Harvard Law School. In his spare time, John is writing a biography of Justice Jackson, and that publication is eagerly awaited by Jackson fans everywhere. Thank you very much, John, for conceiving of and bringing together this stellar group for today's programs.
Thank you so much, Sue and everyone. These topics are on the front burner, and that's why many constituencies and interested people suggested, asked, inquired what the Jackson Center was doing, and it was already in progress and came together today with the program that I think will educate all of us and be very stimulating. The Jackson Center is devoted to education in the live format, in major events and in conference rooms and conversations, in the internet sense of dissemination, and in the afterlife sense of video and YouTube and so forth. And this program will do all of those things. I want to add my thanks to the Jackson Center staff and board, supporters, and community who have brought this together and make this all possible. I also thank the participants who, as you will see, are not only experts but charming, generous people. As you well know, Jamestown isn't exactly next door to most other places, and with alacrity they said yes, and they came, and they will contribute substantially to our education today. I also wanted to thank three friends who were sort of in the background, but were very important in conceiving, shaping, frankly, recruiting, and getting this program to this moment. Professor Charles Weisselberg of the University of California Law School at Berkeley, Professor Tara Mellish of the University of Buffalo Law School, and attorney Paul Fishman, recently the U.S. Attorney for the District of New Jersey, each an expert, each a would have been, could have been, should have been participant, but their absence doesn't mean that they didn't put a lot of muscle behind us all being here today, and so we're very grateful. My topic to introduce this is the historical piece that jumps off from, of course, this man, Robert H. Jackson, and his perspectives, experience, and a little bit of his judicial legacy in the field of immigration. And so I'm going to talk about 5 topics to set up the panel and the rest of the day. First, I want to talk about Jackson and immigration. And just briefly, Jackson, of course, was a descendant of immigrants, as we all are. Now, Jacksons were the old kind, Scotch and British, and had been in this country since the 18th century. Indeed, one might have made it here in the 17th century before it was this country. But they were just people off the boat, and more dangerous boats than many of the later boats, frankly, and worked and settled and proved themselves and assimilated and became citizens as this nation developed, and down through the generations comes a descendant. Jackson was not someone who thought of himself as the real or true or authentic American in juxtaposition to others who came later. He thought of himself as part of that tableau that we regard as our melting pot and our American ethic. And it was part of his relationships, his contacts, his worlds as he grew up. For instance, Jamestown, his town of law practice for 20 years, his adult hometown, was, of course, settled by lots of later immigrants, including Italian Americans and Swedish Americans. And Jackson was immersed in the fraternal organizations, the personal relationships, the communities that those people comprised. For a Protestant, he was, I think, I can't quite statistically prove this, but quite liberal for his time in crossing the street, if you will, in having networks and friends and relationships in Catholic Italian-American Jamestown and Lutheran Swedish-American Jamestown, and I don't mean to leave out, but immigration is not the appropriate word, small but real African-American Jamestown. Jackson valued people and fair dealing and actual individual relationships with people. And this came out in one place that is relevant. I'll come back to it in a little bit. In the summer of 1951, he was sojourning during his summer recess from the Supreme Court in California. And he stopped at Stanford to visit a former law clerk, Phil Neal, who had become a young law professor at Stanford. And while visiting Phil Neal, Phil said, "Would you like to interview my top student for a possible clerkship?" And Jackson said, "Sure." It was kind of a flyer, and I don't think was very serious at the moment. But he met this young man. And this young man, William Rehnquist, of course, became someone we heard of later. He, in the end, when Jackson had a need, was a resume Jackson had, and actually then got hired and became the law clerk, and then, of course, became a Justice Department official, a Supreme Court Associate Justice, a Supreme Court Justice, and the Chief Justice. And in his visits and lectures and remembrances of that first meeting with Jackson, Chief Justice Rehnquist always said, including here, that it wasn't a discussion about law. It wasn't really an interview. It was really kind of a personality encounter, and what Jackson spent his time telling Rehnquist about was Jamestown and the Swedes of Jamestown, because what he found out from Rehnquist, what kind of name is that it is Swedish, and that Rehnquist's ancestry and the immigrants that brought his forebears to Milwaukee were Swedish Americans. And so Jackson sort of told the immigration history, and I think some tales, about Swedes of Jamestown with great affection. And it kind of transferred to Rehnquist in a way that benefited him. Rehnquist should have remembered that, but we'll return to that. Jackson also, of course, became the Attorney General of the United States in 1940. And during his 18 months in that office, the Immigration and Naturalization Service was transferred from the U.S. Department of Labor to the U.S. Department of Justice. It's interesting to think that immigration was once viewed as just a workforce issue and a labor supply question, and thus it belonged in the Department of Labor. In the 1940 period, with Europe at war and other concerns, the Justice Department and law enforcement became the better place for it, and it was transferred into the Department of Justice. Jackson, frankly, didn't love this. And at a fundamental level, one of the things that he didn't like about this was it viewed immigrants not as population, as newcomers, as contributors, as workers, but it viewed them as a law enforcement concern. And he's very explicit about this in his private discussions, in his political resistance. He gets rolled by the White House. Francis Perkins gets it out of the Labor Department. Roosevelt puts it in the Justice Department. But Jackson is fundamentally distressed about this sort of labeling or perspective that sees immigration as a law enforcement project. And he had enough real, if you will, law enforcement projects. But immigration became part of what he supervised, and gave him a sense that he really knew this work of the federal government. And that shows up later in his judging. So let me turn to a second topic, this gentleman. This is Alan Cole, father of Charles Cole, who was Justice Jackson's law clerk during 1949-1950, one of two law clerks. And we'll return to that year in a minute. I want to tell you a bit about Alan Cole, who sadly I have not ever met because he passed away young, but through his widow, Gloria, and through his sons, Robert and Charles, and through his work, which leaves a mark, he's somebody that one can get a bead on. Alan Cole was born in Brooklyn in 1922, grew up in New York City, went to Columbia College, graduated in 1942, and was interested in pursuing journalism. And then, of course, Uncle Sam called, so he went into the Army for 2 years during World War II. He was a warrant officer in the Army, served in Patton's 3rd Army headquarters staff, and in the occupation army, spring 1945 forward, in Germany. He was assigned as a staff officer to, yes, Nuremberg. He was part of the Army Message Center and Code Room team, which basically was in charge of setting up the communications apparatus that connected the Nuremberg courthouse to the Army and the American occupation sector which it was in. And once that work was done, he was a soldier with some time on his hands. So what he did was he sat in the Nuremberg trial when he could get a ticket. They weren't available every day, but he had some chances to go into the courtroom. And one of the things that he saw was Robert Jackson cross-examining the first defense witness in the first defendant's case. Hermann Goering, before he took the stand, called a number of witnesses, and Jackson cross-examined them. And they were laceratingly effective cross-examinations. Well, for Alan Cole, that changed his life plans in a lot of ways. He got out of the service, he came to Yale, he became a law student and graduated from Yale Law School in 1949. He then became a special assistant to the U.S. Attorney General, then Tom Clark, and applied for a clerkship to Justice Robert Jackson. Alan Cole's letter to Jackson played the Nuremberg card. It said, I was a college graduate, I was a soldier, I got to be at Nuremberg, I saw your cross-examination, I threw journalism overboard and went to law school. And I've been looking forward to the moment when I could write this letter. I would love to be your law clerk. What I saw at Nuremberg and what I think law can be and do is what I want my life to be about. And the chance to work with you is the dream that I have. Robert Jackson wrote back this letter, which is a little hard to read. But it's a response in the fall of '48, as Alan Cole is a third-year law student, thanking him for his letter. Your references to Nuremberg strike a responsive chord, for, as you have doubtless discovered, those who shared that experience constitute something of a fraternity. And then Jackson says, I'll get around to hiring a law clerk in the spring. And then responding to something that Alan Cole had offered at the end of his letter, Jackson concludes by saying, I do not think letters of reference and recommendation will be of much help to either of us. In other words, I've got what I need to know about you. And soon that became a job offer, and it became the clerkship, and he's there with Jackson 1949-1950. It includes a case called United States versus Knopf, which I'm going to talk about in a moment. Following the clerkship, Alan Cole serves in the military sector of national government during the Korean War as Assistant General Counsel in the Office of Defense Mobilization, and then he goes into private practice in Washington, D.C., Ultimately, his firm, Cole and Groner, was a very well-regarded and successful litigation shop. Allen was a specialist in civil and criminal practice. White-collar crime and economic crime is what we would call it. In 1976, he served as chair of the ABA Criminal Justice Section. He was a lawyer's lawyer, much like, of course, the man he clerked for. And you kind of see this imprint passing across the career of Allen Cole. He died in September of 1984 at age 62, and so it was not a long life. Ironically, it was exactly as short as Robert Jackson's life. Gloria Cole, who was married to him for 38 years, is someone who has been a friend and is a lovely person, and she's here with us in spirit today. She's vital in Washington, but this trip was a little much. And her sons, Charles, who are here, and Robert, the older son, who's named for Robert Jackson, are important benefactors and supporters of the Robert Jackson Center. So all of that is to pay a little homage to somebody who's part of the Jackson tableau and somebody who is one of the clerks who Robert Jackson really thought was it. It was a very successful clerkship and a very well-regarded mentee to this mentor. So thank you to the Cole family, Chuck, for this support. Let me now turn to the Supreme Court. This is the Vinson Court circa 1949. You see the Chief Justice in the middle. You see Jackson as an Associate Justice in the back row. He's only 3 up in seniority. This is the rookie justice, if you will, Sherman Minton, Harold Burton, Jackson, Tom Clark. I'm sorry, he's 4th up. It goes back and forth. So Minton, Clark, Burton, Jackson is the rising level of seniority. And then in the front row, Frankfurter, Douglas, Black, Reed, and Chief Justice Vinson. This is the court that Jackson, serving on, and Allen Cole, clerking on, experienced in 1949-1950. This court had a lot of cases that pertained to immigration in various respects. And this is a nice, lucky out-the-window photo I was able to take a few years ago of Ellis Island. We think of Ellis Island, of course, in the context of immigration and our ancestors who might have passed through there. My grandfather and my grandmother, each side of the family, came to Ellis Island at different points. But this side of Ellis Island is today's tourist site, the museum, the memorial. This is the Wall of Names. It's the story of the American melting pot. And of course, Lady Liberty is not very far offshore on an adjacent island. This side of the island, beginning here and over to this side, is the side of disrepair. It is not accessible to visitors today. The structures are still there, but the money is not currently being spent by the government to rehabilitate them. And what they are the remnants of detention facilities. Because Ellis Island was a gateway and a holding pen. And for some people, the holding pen was the brief look at your papers, stick out your tongue, take your temperature, check your visa, see if you've got somebody who has a place where you can go and live on the Lower East Side or a job or so forth. But other people are held there by the Immigration and Naturalization Service of the U.S. Department of Justice as detainees, both to keep them from coming in, because in this period of time, Ellis Island is not regarded as the United States, which is, and it's close, but it's an interesting legal distinction at that time, not today. And because the outflow, if you will, of people being deported or excluded uses that as a launching pad. One person who I wish to tell you about is Ignaz Mizet. First, the pronunciation of his name is contested, Mizet, I'm not sure. He was of European ancestry, had kind of Hungarian, but kind of Ottoman Empire, Austro-Hungarian Empire ancestry, and bounced around Europe through the Great War, and then got on a tramp steamer and got to New York Harbor, and allegedly jumped overboard in December and swam to shore. I live in New York. That's something I won't attempt. And got on shore and got started as a person in the United States. No legal status, no visa, certainly no citizenship, and he never ever got around to citizenship, which turns out to be a problem. And he made his way to Western New York. He lives in Buffalo. He works as a cabinet maker. He's apparently a, somewhat assimilated, English speaking to some degree, man of his community. He has friends. He has some political interests. He joins some political organizations. He's kind of making a go of it in this country. And he's not bothering anybody, and nobody's bothering him. Decades pass, 25 years. And then Mzee learns that his mother, back in Hungary, is allegedly on her deathbed. So he wants to go see Mama. He leaves the country, which apparently also was an easy departure process, and never quite makes it into Hungary. This is the Cold War and the Iron Curtain, but bounces around Europe for a few years, and then wants to come to what he regards as home, which is Buffalo. So he crosses back and he gets this far. And then he is detained on Ellis Island. He's detained because the Attorney General has information indicating something raises security concerns about him. And to make the story short, he litigates and eventually gets granted a writ of habeas corpus in the district court. It's affirmed by the Second Circuit, and that case goes to the U.S. Supreme Court. The legal issue is whether the government has to give any explanation for holding this person, or whether the say-so conclusory determination based on secret evidence not to be disclosed by the Attorney General is sufficient. And the Supreme Court in Mzee holds 5-4 that the Attorney General has this power. And so Mzee is continued legally a prisoner on Ellis Island. Justice Jackson is one of the 4 dissenters in the Mzee case. And the little quote in the program is a paragraph that you should savor, where Jackson says this country can afford to give reasons. Yes, we have laws, and yes, the laws give power to our immigration authorities, but basic due process means giving a reason or an explanation before this power in this draconian way is used against a person. Mzee was trapped on Ellis Island because he couldn't get a visa to go anyplace else. He was a man without a country. And he was there for quite a while until, frankly, the Cold War climate seems to have broken, and the Attorney General somewhat quietly released him into this country in 1954. And so he did make his way back to Buffalo. He had a wife thereafter and 4 stepchildren and lived in Derby, New York. And after she died in 1969, he sold the home and took the money and went back to Hungary, and not much is known after that, but he apparently died in the 1970s. He was an American, but never a citizen, a person of rights, but not sufficient rights, not to be moved around like the chess piece that the Department of Justice treated him as. Justice Jackson said one more thing I want you to think about. He didn't understand, this is from his Mzee dissent, why the government was afraid to tell Mzee why it was afraid of him. One more case. This occurs during the earlier term, 1949-1950, when Alan Cole was a Jackson law clerk. It concerns a woman named Ellen Knopf, who was a war bride of an American soldier. And after World War II, she was European, German. After World War II, the statute authorized the entry of war brides because guys in the occupation army met and married. This is when fraternization became Frauenization and war brides were a reality. And the Congress responded. And war brides were eligible to come into the country. It was immigration liberality, if you will. Except the Attorney General regarded Ellen Knopf as a security risk. Slim discussions eventually emerged that there was some rumor that she had provided some kind of intelligence assistance to communists in Czechoslovakia. The details of that were never disclosed. She also was held on Ellis Island. And maybe there's a little bit of sexism in here. She became, even more than Mzee, a cause celeb. This is a cartoon of a little figure, Statue of Liberty in sight, standing outside the huge wall with the hand of the Attorney General holding out, secret decision to keep her out of the country. Dangerous patterns of the Ellen Knopf case is what the cartoonist captioned it. When her case goes to the court, basically the same issue as Mzee is what the court is considering. And basically the same outcome is the way the case is resolved. The Attorney General has this power and may keep her out. Justice Jackson is one of the dissenters, and I will read you, well, hold for now. Some of his language is also very powerful, as in Mzee. The government, having won this case, then decides we're going to send her back to Germany. Unlike Mizet, they could send her back because the U.S. military occupation and so forth made an open door in Germany. And the government is doing that in a hurry-up basis. Justice Jackson, whose supervisory responsibilities as circuit justice included the Second Circuit in New York, learns about this on the morning that she's on the plane in New York to be launched out of the United States. And so Justice Jackson stays that deportation. So there's the full court decision, and then there's the individual Jackson decision in May of 1953. Ellen Knopf stayed at the last-minute order of Jackson, and there she is. It's not a detention authority who's grabbing her. This is another picture of her after the happy news, waving from the car that took her back to Ellis Island after her deportation was held up at the last minute. Jackson uses scathing terms in rebuking Justice Department effort to thwart her appeal. Another cartoon. Star Chamber Justice, in other words, our government, the deportation authority, reading Justice Jackson's stay order. And the caption is, "Almost got away with it." In the Knopf case, this is what Jackson wrote. The government tells the court, this is the full case, that not even a court can find out why the girl, forgive him for his sexism, is excluded. But it says we must find that the Congress authorized this treatment of war brides, and even if we cannot get any reason for it, we must say it's legal. Security requires it. Here's the money quote. Security is like liberty, in that many are the crimes committed in its name. The menace to the security of this country, be it as great as it may, from this girl's admission, is as nothing compared to the menace to free institutions inherent in procedures of this pattern. In the name of security, the police state justifies its arbitrary oppressions on evidence that is secret, because security might be prejudiced if it were brought to light in hearings. The plea that evidence of guilt must be secret is abhorrent to free men, because it provides a cloak for the malevolent, the misinformed, the meddlesome, and the corrupt to play the role of undetected and uncorrected. I am sure officials have acted here from a sense of duty, with a full belief in their lawful power, and no doubt upon information, if it stood the test of trial, would justify the order of exclusion. But not even they know whether it could stand this test. And anyway, as I have said before, Mizet, personal confidence in the officials involved does not excuse a judge from sanctioning a procedure that is dangerously wrong in principle. Robert Jackson was a law enforcement official. He was a national security official. He was a believer in the sovereignty and national security interests of this country. And he was a lawman, which means as a judge interpreting the protections, some constitutional and in this realm more statutory, that require certain showings, certain procedures, certain demonstrations before individuals can be launched about and mistreated willy-nilly. It's something that long before we were talking about immigration, we all know and are familiar with as a strand in Robert Jackson personally. This is Fred Korematsu, a U.S. citizen. So let me be clear, this has nothing to do with immigration. Fred Korematsu, of course, was of Japanese-American ancestry. He was American-born, Nisei. His parents were immigrants, Issei. And the Army orders and the criminal laws backing them up in 1942 put him under a curfew, which Jackson was one of the 9 justices that unanimously upheld, and then excluded him from the West Coast, which is what his case is about, which Jackson is one of the 3 famous dissenters regarding, and then sent him inland to an internment camp for a couple of years during the war until the security threat was believed reduced enough to parole him out. When, by the way, of course, he went to Detroit and worked in American defense production, which shows the lunacy of the broad brush that painted over him. In the Korematsu case, again, a citizen case and a constitutional case, Jackson said this, which is about this thread, which is Korematsu and Knopf and Mizet and other things in Jackson's career. Here is an attempt to make an otherwise innocent act a crime, merely because this prisoner is the son of parents as to whom he had no choice and belongs to a race from which there is no way to resign. The broad brush, call it a religious broad brush, a racial broad brush, a national origin broad brush, that denies individual assessment, is the common issue that runs through these cases, the constitutional and the statutory cases. And Robert Jackson's view was that an American jurist's duty was to ask more from his government than that. Thank you very much.